Good morning, ladies and gentlemen. Good morning, those in the house. Thank you so much. Welcome, ladies and gentlemen, once again to this 32nd edition of our weekly press and public engagement, the Uganda Law Society. I am by the name Robert Benon Jirua, a litigation officer in the Rule of Law Department at the Uganda Law Society. It is my singular honor to welcome you all to yet again another day that the Lord has given unto us to engage with the public and the members in general, and we want to thank the Lord for this far we have come. We would like to begin the day with a prayer to usher the day and the activities of the day. So as to move forth, we'd like to kindly request Council Alan to come and lead us in an opening prayer. Thank you so much.
Let's humble ourselves and pray. Heavenly Father, in the name of Jesus, we come before thy throne. We give our lives to you, and we pray, O King of Glory, you guide and direct us throughout this session. We thank you for life. We thank you for everything. In Jesus' name, amen.
Thank you so much. We would like to introduce a topic, a very intriguing topic, just fresh from the recent Tech Fest, which was also IT related. The Radical New Bar, under its mandate in Section 3 of the Uganda Law Society Act, that mandates us to both sensitize the public and aid the government in as far as administration of justice is concerned, as well as access to justice, which of course also helps to appreciate that we are in the practical steps of implementing that mandate. We have a topic today titled Copyright and the Future for Performing Artists in Uganda. Copyright and the Future for Performing Artists in Uganda. This is a topic that might sound very odd to the general public, but of course to the members that are both here physically present and those that are online, because this is a digital platform. We have members that are following us on X, formerly Twitter, members on YouTube and Facebook. We want to thank you. We are very aware of the following. We want to appreciate the time that you've taken off to listen in. And this copyright aspect is something that is not so new to the lawyers, the members, but very important because it is going to discuss matters that pertain artists. Artists, we mean especially the musicians, but we are also going to delve into what we call creatives. A very rare word, we know, but that is what the Radical New Bar does. It brings to you things that are new for you to espouse your knowledge as well as be a relevant and important citizen to your own self and to the country of Uganda. So recently, and for very many years, Uganda's copyright landscape has been faced with critical gaps that have left our performing artists. In performing artists, I'm going to request you to interpret as musicians for easy understanding. Our musicians have been very vulnerable, and creators continue to suffer significant losses as their work is either reproduced. I know you've already heard about musicians. I know there's a lot that is going to be said about them, and in which there's production. We've heard of those words of production of a music piece. There is piracy, when there's a piece of music that has been produced and someone else pirates it, we shall hear the words coming in thick and thin, and others are altered without the consent of the owners, as we call them, or the people who produce, or rather who create these kind of arts. Or apart from without consent, we are lacking what we call adequate protection for these creatives or the artists. And this has, of course, not just only undermined their livelihood, but it has, in a way, stifled their growth because, it is very hard in this Uganda of ours to come up with something of your own or anywhere else. Even you as an individual, coming up with something of your own means you've put in some good, energy, some effort. And for anybody else who has not done any of that nature, to come in and take it away from you is quite something. So the creatives and the copyright is something that is going to help us to appreciate a few things in that area. So in recognition of these challenges, the Copyright and Neighboring Rights Amendment Bill 2025 was recently tabled before Parliament. Its reading. The bill aims to modernize, among other things, Uganda's copyright framework, aligning it with international standards and addressing issues related to the digital age. On the 13th day of August, that is around a week or so ago, the Uganda Law Society and other stakeholders such as the Uganda National Musicians Federation was invited to the Legal and Parliamentary Affairs Committee to present comments on the bill. We were ably represented by our intellectual property cluster that is under the Uganda Law Society, including an individual who is in the house here to help us delve into what transpired in Parliament. So today's RNB is focused on further expounding on this issue to the effect that the plight of performing artists in the face of copyright infringement is to be understood. But without going any further, would like to welcome you to the house by way of receiving a message from the CEO of the Uganda Law Society that is going to be delivered by one of our own staff inside here. So please welcome with me Miss Angom Ruth, who is going to deliver the message from the CEO of the Uganda Law Society. Thank you so much.
Thank you, Robert. Good morning, everyone. I'd like to take this opportunity to welcome you to yet another edition of the Rnblive series. Thank you for coming. I'd like to also welcome our guests that are here. You're most welcome. Yes, as Robert has already highlighted, I'm making remarks on behalf of the CEO, who is currently indisposed. And it reads, our special guests today, Mr. Francis Peter Odeje, Mr. Martin Muhomuza, Advocate Kenneth Muhanji, ULS Council members present and online, members of the Uganda Law Society, joining us both physically and online, members of the press, ladies and gentlemen, good morning. I welcome you to the 32nd Rnblive weekly press and public engagement. I thank our membership and members of the public who have consistently followed our weekly engagements. We value your feedback and we encourage you to continue engaging with us, especially on our online platforms. Today, we have one issue for discussion: copyright and the future of performing artists in Uganda. On 13th August, the ULS appeared before the Committee of Legal and Parliamentary Affairs at the Parliament of Uganda to give our opinion on the Copyright and Neighboring Rights Amendment Bill 2025. To further elaborate on the important issue, we are honored to be joined by three distinguished guests. Mr. Francis Peter Ojede, Executive Director, Uganda National Cultural Center. Mr. Martin Muhomuza, Director of Research at the Uganda National Musicians Federation. Advocate Kenneth Muhanji, Partner at KTA Advocates and an expert in intellectual property law. At the end of the discussion, we shall have a Q&A session which is open to both the physical and the online audience. I encourage you all to participate and deepen your understanding of copyright law in Uganda. Once again, I thank our ULS members and the public for always joining us every Thursday for these important discussions. We value your presence and your input. You're all very welcome. Those are the remarks from our CEO, Ms. Christine Awori. Thank you.
All right. right, thank you so much, Madam CEO. I could only imagine you're following us online for your remarks to be read out. For those beautiful words and for the welcome note, we'd like to thank you and we wish you all the best in your endeavors wherever you are. Ladies and gentlemen, without further ado, we want to delve straight into the meeting and the discussion of the issue at hand. And with us, we are going to be welcoming an individual, a very responsible citizen who has over 20 years experience in human resource. He has previously served as the head human resource planning and development at the National Planning Authority and also as the head human resources management department at the Electoral Commission. He holds a master's in public administration and management from Makerere University and a second master's in human resource planning and development from Guru Gobind Singh Indra Pasha University in India. The details are going to come with the owner of the accolade. Ladies and gentlemen, with me would like to welcome Mr. Francis Ojede, the Executive Director of the Uganda National Cultural Center, UNCC, to speak to us. Thank you so much. A round of applause. Thank you. You are also requested to come over here, if it's okay. Thank you so much.
Our Master of Ceremonies, the President of the ULS, members of the Law Council, distinguished lawyers in your different capacities, ladies and gentlemen, my colleagues that are going to make presentations, the press. I want to thank you very much for welcoming me here. And I want to once again say that I associate with you in terms of presentations of issues that are of importance to this country. I was invited, I was away, but I was able to see the invitation arrived yesterday, and I thought that would be important that I come, because it's a topic that is very important for all of us. I crafted my paper in a fairly different way. I called it a paper presenting the plight of artists and the need for comprehensive laws and regulations on copyright and other art and culture laws. And that is how I decided to craft it, and I'll be able to present the few things. First things first, I want to bring you greetings from the Uganda National Cultural Center, where I serve as the Executive Director. I've already been introduced, and I don't want to go into the details. Maybe what I want to say is, because this is a professional body, I also served as the President for the Human Resource Managers Association of Uganda at some stage. So that associates me with you as a professional body. It is indeed a great pleasure and privilege for me to be part of this discussion as an invited guest speaker. Let me briefly talk about art and culture, because if I talk about intellectual property and I talk about all those issues before talking about the people that and the sector that is responsible, it would be in vain. So let me talk about art and culture, which now is widely known as the creative industry, and how important it is, before I can then highlight the plight of artists in Uganda, especially when it comes to intellectual property. Culture and creative industries, which is commonly known as CCIs, in Uganda comprises the creation, production, marketing, and distribution of products and services resulting from human creativity. So we're focusing on human creativity. So we're looking at them. And when you talk at CCIs, those are the issues you're looking at. I'll refer you to a few authorities and then also some few of my experiences. According to UNCTAD, the creative industries deal with the interplay of various knowledge-based economic activities comprising tangible products and intangible intellectual assets. And I want you to emphasize this, the aspect of intellectual assets. With economic, okay, fine. Assets. With economic and cultural value, creative content, and market objectives. The CCIs in Uganda has 12 main domains that include music, performing art, and celebrations. I earlier on had, I was talking about performing arts and mentioned it as music. They fall in the same category but clearly defined. Collective societies, film and video, visual art. This is where you are able to draw, you're able to see, you're able to also feel. So it is visual art and craft, fashion and design, books and publishing, software and innovations, and then cultural and natural heritage. These are the areas that we're talking about when we talk about the creative industry. And we also add the aspect of advertising and marketing, communication, then culinary and gastronomy. We're talking about foods and drinks, and basically, and creative allied services, the support that are usually provided for this. This all constitute what we call the CCIs. And each of the domain is a fully fledged industry that functions and does everything that you talk about in the art. As a universal resource, which is the CCI, creativity is a key factor in economic growth and sustainable development in all regions of the world. Notably, the cultural and creative industries are one of the fastest growing markets in the world. The culture and creative industry sector accounts for 3.1% of the global GDP and 6.2% of all employment, and that is according to UNESCO in 2022. In 2030, the cultural and creative industries are predicted to account for 10% of the global GDP. According to pre-pandemic forecast, that is, in addition to countries of the global south, trade in creative products grew disproportionately from 25% to 45% within 10 years from 2002 to 2014. That's according to the World Bank in 2020. It's further underscored that the positive trends which occurred globally is expected to continue into the next decade in Africa. We have in Africa, countries such as Nigeria, Ghana, Egypt, and South Africa are also emerging as big exporting countries of the creatives. In East Africa, we have countries like Uganda, Kenya, and Tanzania that have also emerged in terms of the export of the creatives. In East Africa, exports of creative goods and services was estimated at $2 billion in 2014, and many scholars regard creative industries in Africa as untapped gold mine. This is the issue that is coming up. Uganda's culture and creative industry have evolved from merely being activities for leisure and pleasure to a major economic sector contributing to national growth. The CCIs contribute to the country's revenue targets through both non-tax revenue, NTRs, and direct taxes. Estimates for NTRs show that government could generate approximately 2.6 billion from the license fees and 1.8 billion from, and I'm going to go quickly on this, and maybe there's so many figures that some of them I will allow you to read. My paper is up there. From registration of business fees. It has also been reported that CCIs have high tax potential. As of June 2022, URA collected 106 billion from public entertainment events. URA collected 106 billion from public entertainment events. An extra 39 billion is the estimate collected in taxes on value-added services offered by telecoms, that is, including collaring back tunes, which we are going to talk about. A mapping study by Minister of Gender, Labor and Social Development and UBOS in 2014 indicated that a total of 386,000 people have directly been employed in the art and culture or creative sector. UBOS also conducted a survey in 2013 that found that there were more than 12,460 SMEs in culture and creative industry in Uganda, which number is likely to be much higher today. This is very important for us to be able to know what we're talking about. According to UNCTAD in 2023, throughout this decade, the creative industries are ranked as one of the most dynamic sectors in the world economy and international trade. However, Uganda, like other emerging economies, are yet to harness the potential of the creatives. There are over 32 revenue streams. I want to repeat this so that we can package this well. There are over 32 revenue streams within the CCIs that could be attended to. 32 that brings out broken, and you're able to get something out of them. And we need to tap into them. The potential for the internal market for cultural goods and services in Uganda is estimated at about 7.05 trillion. And this is as a result of a study by the Minister of Gender, Labor and Social Development in 2022, and is growing with the rising population and income. Uganda's annual economic growth has been averaged at about 6% over the past 10 years. And this, you could see how related it is. All of these developments are increasing the demand for culture and creative goods and services. Yet there has been no corresponding growth in the culture and creative sector. Cultural products and events are few. The development plans in this area are therefore still limited and requiring attention. Ladies and gentlemen, I thought I should give this background with statistics for you to be able to see this sector we're talking about, the CCI, the creative sector. I am therefore going to take you to my second part of the underlying problem in the sector. The culture and creative industry in Uganda is a fast-growing sector with great economic potential, which is, however, largely untapped. This is mainly because of the lack of recognition and understanding. I want to say this, the sector is not understood and not recognized. There was a time when you talk about art and culture, then I would want to use this because I was being asked when I started going there, are you talking about this witch doctors? Are you talking about these things? That's what somebody will talk when you talk of art and culture. And it is not. I've just been able to demonstrate to you what it is. It's a CCI. and it's completely. So the lack of recognition and understanding, and therefore if you don't understand something, you don't put importance to it. So government has for that not been putting a lot of interest in this area, and that has affected its growth. Culture and creative industries are highly capital intensive. We need a lot of money to be able to invest, and of course, if you don't know it, you don't appreciate it, you're not able to put some. And government has not yet been able to prioritize these investments. Of course, now government has put the creative sector as a number 4 in terms of priority, in terms of the areas that should prioritize on it. So now it has begun to appreciate it. But in the past, culture and creative industry was never thought about. Another area that I wanted to emphasize is I'm saying it is expensive, capital intensive in terms of infrastructure and also in terms of the technology that we require. It's very expensive to put a building like the National Theatre, which with the fully fledged and anti-theaters, the theaters, and also the recording studios and so on. So it's expensive. In addition, accessing investment financing from the financial sector by CCIs is a challenge due to the perceived risk associated with these industries. I would give you an example of somebody has an intellectual property on his music and so on. The banks are not willing to pick that intellectual property for now in Uganda, and yet it is a bankable aspect. So we need to be able to bring out this. So they're not able to access financing, and yet they have the money. And these are issues that we need to be dealing with. Financial institutions and stakeholders often prioritize more traditional sectors such as agriculture, energy, and industry, leaving the culture and creative sector struggling to secure necessary resources for investments. This lack of funding restricts the development of the creative talents, infrastructure, and innovative projects. Technological advancement and the rise of digital platforms have reshaped the landscape of culture and creative industries. However, not all individuals and organizations have access to technology or digital literacy due to financial and other limitations, which hinders their ability to fully participate in the digital economy. Many of our people in the villages are not able to access the digital platforms. And for that matter, they're not able to participate. And yet, for us to be able to call this creative industry, everyone has to be involved. I tried to summarize a few things that I think are issues. In summary, the following are the inhibitors to the creative sector's development. Number 1, there's the weak legal and regulatory framework for culture and the creatives. We do not have strong laws and regulations. We've just been looking at if you look at it from the institution that I serve, the Uganda National Cultural Center, and for your information, this law was established in 1959. It's still the same law we're using today. So many things have changed. Most of us were not born here. I'm sure almost all of us. But that's the law that we are using today. And it served that purpose. It has served, and I think it needs to be either repealed or amended significantly to be able to address we have just been looking at the copyright, a neighborhood law of 2006. Yes, it's undergoing changes, reviews, and amendments. But if you look at it, if you went in, you realize that it lacks a lot, because at that time, first of all, perception and knowledge of the sector was not there, and therefore, so many things were not put there. So we need the legal and regulatory framework for the culture. We've just been looking at the culture policy of recent. Just a month ago, we were just trying to conclude on it. These are issues that we're looking at. The old one was in 2006, and you can see that the changes over 20 years, we're now trying to do the change. So this is very important. We need to, so there is a weak legal and regulatory framework. The second aspect which we want to talk about is the lack of a strong art and culture institutions. We do not have strong institutions that are in the art and culture sector. We don't even have the obvious ones, the CMOs, collective management organizations, such as UPRS and Euros. They're not strong. They're very, very weak. We need to strengthen them for us to be able to harness these issues. There's also inadequate cultural and creative infrastructure and facilities. You'll be shocked to see that in terms of government facility, the only facility in the art and culture industry in the whole country is the National Theatre. It's the only one. The law says, the act says that we should be able to establish cultural centers countrywide. But we have one. How many districts do we have? Almost 146 there. But we have one. So we need to be able to expand. We need to provide services nearer to the people. And these infrastructures need to be moved. Of course, there are plans by government to start regional centers. But even the regional centers, I mean, if you're going to put 4, then 4 out of 146, I mean, it's just a drop in the ocean. But still it's better than nothing. Then we have lack of appropriate technologies. A lot of our people are still using archaic technology, outdated, and we need to be able to establish. And we were talking about common user facilities in terms of technology. Put it in one place where everybody is able to use, maybe in those regions. But then they must be up to date. But we have a lot of technologies that are not up to date. There's limited access to appropriate investment financing. I talked about this. Investment financing, we cannot, the creatives are not able to. You have your copyright like this, you're not able to sell it, and yet it's money, a lot of money. The banks don't know it, and they have no mechanism of accessing and saying they actually look at it as very high risk. They do not want to look at you. And this is one of the things that we're saying that government then needs to create another avenue for artists to be able to access financing. There's low levels of comprehensive competence in professionalism and entrepreneurial capability. You realize that in the CCI, we accept everyone to be part of it, and therefore, and yet you want to compete internationally. So yes, you're going to produce a song, you're going to do some drawings, but they're not going to meet international standards. And therefore, we need to professionalize those aspects. So we train, we can do master classes, but we're not able to do it for now. And that helps us with aspects. So there's a problem of low competence and professionalism. We also have the aspect of weak coordination mechanisms for the culture and creative sector. I will shock you to know that we do not have proper coordination in terms of this sector. A lot of the sector players, they go to Uganda Communications Commission for issues that relate to them. They come to Uganda National Cultural Center for issues that relate to them. They go to the Ministry of Gender, and they go to, many institutions. You go to Ministry of Justice, and they also are able to. We don't have a problem with that, but we're saying there must be a coordination mechanism so that they're able to be strengthened. There's also lack of organized market for the creatives. We're talking about the international trade, but you don't see the creatives in the international trade. No more so in Uganda, you don't see them. The other day I made a comment and said some of our people should be able to link up with the Uganda National Chamber of Commerce. When I say this, some people think I'm wrong. Some people think that I'm trying to chase them away. But no, this is the area where business lies. So you should be able to link with them. So you realize that the creatives need markets, and you need to link up with institutions that are able to. We're talking about UTB, Uganda Travel Bureau. We should be having these aspects with UTB so that some of our products are marketed internationally. There's non-formality of the sector, and therefore there's a lot of disorganization. We as a sector we have been very disorganized. Of late, we are getting organized, but we have been extremely disorganized. With individualism, I will talk about with individualism. It is me, I know it all. And that has been a problem with the sector, and yet we could complement each other. I know this area, the other person knows, and we'll be able to. We're doing a lot of work to make sure that this is done and this is dealt with. But still, we have the issue of individualism and the aspect of disorganization. There's poor quality products that make it difficult to sell our art and culture products internationally. We do not produce, at the moment, high quality products. And it's a reason, comes from very many reasons. The capacities, the equipments, the tools, and all that. Once they're put in place, we should be able to address some of these issues. I thought those should come out as a wind-up. Those are key issues that I thought I would talk about. Let me speak a little bit on the current Copyright and Neighborhood Act review. And I'm saying the current Copyright and Neighborhood Act of 2006 is a good starting point for the creatives. However, it has some gaps that need to be plugged. Amendment process has started and is now in Parliament, and I'm glad that you were able to participate in the process. And a lot of stakeholder engagements have been done, and quite a lot of issues have emerged and proposals made to them. It is our hope that after the amendment of the Act, it should be able to facilitate the growth of the sector and also protect artists and their works. Because basically, if I really have my products and intellectual property that is protected, that is my money, and that is where we're talking about. So we need to strengthen that aspect. The biggest challenge that was raised in the process of the amendment has been the issue of piracy. We talked about it. We have had issues of piracy. I produce my song, and at the end of the day, I get nothing out of it. There's somebody earning big for me. You'll later on hear terminologies which I'm going to bring called aggregators. I will explain later, I will talk about them. They come, and they're there. They're the ones that collect all the songs and so forth and sell. And they sell it at their price and give you just a peanut. So it is like you're singing for the aggregators. And that needs to change. The government needs to come out with strong regulations to be able to manage these aggregators. And most of them are foreign aggregators, because they have to invest a lot of money, and the government needs to support our artists to be able to establish such aggregators, or the business community to establish, but within a framework. A number of the artists' works are pirated, and as a result, they lose out what they should have been their gains. Enforcement has therefore been very, very, very weak. We need to emphasize the aspect of enforcement, of implementations, and also on the issues of the copyright. They must be enforced so that people's rights are not violated and people are able to earn from what they have produced. The second issue that has been raised is the issue of aggregators. I've talked about it, whom artists feel cheat them. There is currently weak legislation regarding regulation of the aggregators, especially on the aspect of regulations. If you went to what the aggregators do, they decide that I am collecting for an artist, or I'm collecting for artists. And they can decide and say that they will earn per song played. They will probably earn 40% of that money. Then 20% will probably go to UCC or to the telecom company. Goes to telecom company. 20% then, 20% to the telecom, 20% to the regulator. And then you, the owner, you remain with 10%. Can you imagine? We're talking 100% and you get only 10%. This is the problem, and there must be a reversal of this. If anything, the 40% should actually be to the producer. This is the issue, and we need to continue emphasizing it. And that's where the aspect of aggregators becomes very important. The other issue which artists raise relate to the ringtones. We normally know you always have in your phones the playback, the ringtones that are there. They are made by people. They are artists who have come up with those ringtones. They must be paid for. And in a number of occasions, the telecom companies are not adequately paying for them. They normally do a one-off buy-off. They buy it off from an artist, and then they start ripping from the artist. We're saying there must be regulations on this to be able to allow the artist to earn from whatever, so that if I played your ringtone, you should be some part of the money every time you ring should come to me. And that is where we're looking at regulations and frameworks. And there is a proposal that there must be a framework regarding regulating the pricing of the usage of the caller ringtones, which I have just been able to explain. There's also an issue which is being raised that government should come up with subsidies on equipment that are used for producing music, films, and many other artworks. So artists are proposing subsidies so that the prices that on these items are reduced, so that they're able to import and be able to do their work at a lower cost. Because at the moment, the pricings, the cost of production is being high because the pricing of these items are extremely high. They're also proposing that apart from putting subsidies on the items that are coming, we should impose some taxes on some items that try to infringe on the usage of our products. They should be taxed, and that is an issue that they're raising. Obviously, there are two coins, there are two sides to it, but of course, that is the proposal that is coming in. Lastly, that the law should provide for how licenses and collection of royalties for artists from users such as bar owners. I'm bringing this so that you're able to hear. They're actually saying you should license the bar owners, and then their royalties and all, some taxes that are got from them, so that it goes towards the owners. So we have to tax the bar owners, taxi owners, taxi and bus owners, radio and TV stations, so that the money that is got from there is shared. And there must be a sharing mechanism that is provided for in regulations. Ladies and gentlemen, I know that with the time that I've been given, I may not be able to speak on everything, but I thought that I should, as an institution that deals with the art, and I should be able to speak a little bit on some of these, and I thought I would do that. And therefore, I'd like to thank you for listening to me. I know that there's going to be more time for question and answer, and I will be able to elaborate more. Thank you very much, and God bless you.
Wow, that was a very deep presentation. May we please give him another round of applause? Mr. Ojede, you surely heaven sent. We know, as you said, the act is 1959. It is older than all of us, including, I don't know you, I'm not sure. Imagine all of us are dealing with an act that found us here. So we want to take the opportunity to appreciate, because we have also realized that the way he has given us, those figures are very staggering. The 3.2 billion, the 3.1 billion for the global GDP, 6.2% rather, global employment. And just here in Uganda, Mr. Jeda, who is your best artist in Uganda? Just activate that mic. Just press a little, press that mic. Who is your Kadongo Kamu, I don't know, 1960, Paul Cafero.
We have the Paul Cafero.
Okay, okay. Pelko Pharaoh was your favorite artist? Okay, thank you. I'm going to just choose a little. Miss Agnes, who is your favorite artist? Namubiru, over there. Just feel free. We're just going to do a random thing because this is going to help us get into the next topic. Who is your favorite artist? Levixon. Okay, awesome. Mr. Ezra, who is your favorite artist? Bobby Wine. Okay, you can see. So the next topic, after we've had a very comprehensive discussion from Mr. Ojede, which I think is supposed to speak to us. You know, we are the human beings and the fans of Bobby Wine, Levixon, Paul Cafero, may his soul rest in eternal peace. And we are asking questions like, do you know what happens when your favorite artist's song or rights have been breached? You know, if they have been pirated, what happens when a company's use of an artist's work sparks a legal battle? Because this is the Uganda Law Society, where we bring to you things that are very unthought of, unheard of. And the radical new bar for that particular matter is here to disrupt the old. We're here to bring to you things that you would not think about, and yet they are very important. Just imagine you're in the same vehicle, be it a bus, with a favorite artist of yours, and on the back of the bus is his photo, Bobby Wine, whatever they call all the things that have been put about him. And how can creatives safeguard their intellectual property in Uganda's evolving creative industry? That is for the lawyers. There are very many lawyers, for you to know, Mr. Jede, that they have not yet gotten their calling or their practice expertise. And yet creatives is speaking 1.8 trillion, bringing to tax to Uganda. We're speaking 2.6 billion in licenses. We're speaking 1.8 billion in registration fees. Guys, for the lawyers, members, those physically present and those online, the next individual going to talk to us is going to help us to understand what it means for you to be a creative, because being a creative has been said to be a human development of your own, right? So you don't have to go out of this country. Just be in your room, bring your idea to fruition, and look for Mr. Jede. Now he is in the records of the Uganda Law Society, and the Radical New Bar has brought him physically present for you. So ladies and gentlemen, would like to thank Mr. Jede for that very comprehensive report. There's of course not so much time for us to delve into everything. We shall request that the paper remain behind and we can submit it to the members, of course online. The council is very happy with the presentation, and it is the role of the council to disseminate this kind of information. But as we go forth, we're going to listen in to the next speaker, who is a specialist in intellectual property law, that discussion that we want to have. To add some spices, I think we're going to put, I don't know what chirungo you're going to put, but I first leave them. I don't want them. Okay. This individual is an IP law specialist and policy with expertise in technology, law, data protection, and emerging technologies. He has advised governments, not just one, international organizations, and the private sector on IP frameworks, ICT regulation, and innovation policy, including drafting Uganda's Data Protection and Privacy Act, and the most recent taking part in the 2025 Copyright Amendment Bill. He represents Uganda in global fora such as World Intellectual Property Organization, and has engaged with the World Economic Forum Center for the Fourth Industrial Revolution. He lectures IP, that's intellectual property, at Uganda Christian University, and cyber law at Makerere University. He sits on the board of the Financial Technology Service Providers Association. He convenes the Carbon Markets Association of Uganda, and he chairs the East Africa Law Society TMT Committee and the ICT cluster of the Uganda Law Society. Ladies and gentlemen, with that very heavy CV that I could not complete because of time, welcome with me Mr. Kenneth Muhanji, who is a partner at KTA Advocates.
Kajambo. Good morning, or is it good afternoon already? Thank you for that introduction, Robert. My job today is, now I don't know what there are people who are watching online. I think most of them are advocates, so we're speaking to advocates, we're speaking to creatives, and also the general public. Okay, so I'll try, and my focus is going to be mostly on those first two. That is advocates and then the creatives as well. And the general public can also be able to step in here to see where they can learn. They say that he who hungers to grow must sharpen their mind with a pen. And I'm hoping that these engagements like the one that we're having here will help us to expand what we already know and perhaps be able to add more. Maybe I'll start with something Robert mentioned, being a lawyer, there are many who are practicing law and can also practice other professions, or perhaps, I think we call them hobbies, but what I want to share with you today is that those hobbies can also become something tangible. They can turn into gold. And for many advocates, we also know that you're also poets, you're also musicians, you're also artists, you're also lyricists, you're also copywriters. By virtue of you going to those 4 years of law school, and then you do that 1 year of LDC, and then of course that struggle to be able to get into this rat race. Throughout that entire time, you're writing briefs, writing this, but some of you can also be able to write poems, can also be able to sing, can also be able to contribute in that particular regard. And I feel that in that line, once you have more learned friends in these particular industries or these particular professions, that will continue to grow, because it is a privilege for you to be an advocate and for you to be a lawyer. Maybe I'll also emphasize that we are looking at the Copyright Amendment Act, and which I'm going to introduce to explain to you what our copyright law is and the amendments that we have. But I also just want to remind you that in the past we've always looked at policy or law from the context of, if I mention policy, many of you will think about government, right? But this policy question also affects you as lawyers. And today I'm also going to introduce and show you how policy can work for you in terms of being able to expand the opportunities. We are complaining that many of our colleagues, especially the younger lawyers, do not have means to be able to practice law, do not have opportunities. Well, I am telling you that for all of us, the practice of law is pegged on policy, is pegged on laws. Whether you are in litigation, whether you're a commercial lawyer, your bread and butter is as a result of the laws that you're trying to enforce. Now, it is also possible for you to shape these laws. And why you should also be intentional about understanding what is in these laws is so that you can be able to see what opportunities are present for you as a young lawyer, for you as a practiced, as a seasoned advocate, for you who is also trying to add more or to expand your practice in whatever field that you have. And I'm going to take you through some of the amendments that will affect you and will help you as well to be able to tap into these figures that I've been talking about, trillions of shillings, mulid. And they say that the economy is tight, but the issue is that we don't know where these opportunities lie. But also as a body ULS, we are not working with these institutions to see how can we collaborate in ways that open up opportunities for our members, but also ensure that the public is benefiting in that regard. But we are talking about copyright. So I assume we already understand or we know what copyright is, but for those that may need a refresher, copyright is an intellectual property right. And what that does is it protects expressions. These are either literary works, dramatic works. More recently, we've also even gone into performances, either in the public or on screen. So basically, any form of works that are expressed, these are protected under copyright. And it's one of the few intellectual property rights that is inherent. You don't need to register copyright for it to apply. But according to this amendment, that is one of the biggest sellers or points for advocates, because now we are saying that if you do not register some aspects of that copyright, you may not be able to enforce it, and that is good for you who represents these artists, who represents creatives, or you're creative yourself, and you want to be able to expand in that. Now, our current Copyright Act was, or the one that we are amending, was passed in 2006, has undergone a few amendments, but one, we didn't have adequate provisions that looked at online piracy. And so the new act looks at that. I'm going to explain where that focuses. We also did not have clear modes of remuneration for performers and also for collecting societies as well. So this new amendment brings out what we call caller-back tunes. So these are things that have already been there, where if you call me, I have a song, you didn't ask me my favorite artist is, I'm a Shibaholic, Shiba, well done. But if I have Nkwatako and you call me and that's what you're listening to on the other side, some money should be able to go back to Shiba. And so this law makes it clear what are the percentages that should be going to these artists. And again, I'm really emphasizing that the law can work for anyone. And the laws that we have should be able to work for you and me and the clients who we represent. And so this is a very forward-thinking provision. I will go into that later. We also had a few restrictions when it came to infringement, even in terms of the scope of and remedies, adjudication mechanisms. It has empowered the Registrar of Copyright to be able to handle a few other disputes. We had also failed to domesticate a few treaties. That's the World Intellectual Property Organization treaties like the Berne Convention on the Protection of Literary and Artistic Works, the Marrakesh Treaty, and other treaties like even the TRIPS Agreement, and also the Beijing Protocol on visual and audio works. So let me now look at amendments that may relate to us. Under Section 2, the amendments introduce things like accessible format copies. They tell us who a beneficiary person is, and orphan works. So what these basically introduce is that according to the Marrakesh Treaty, to facilitate access to public works for persons who are blind, we needed to have the law reflect those in our communities, those in our societies who are not able to read and to see these, or to enjoy these literary or artistic works the way that we can enjoy them, those of us who are fortunate enough to be able to do so in the way that we do. And so accessible format copy beneficiary persons, these were definitions that extend or include these visually impaired people into the amendments under the Act. And we're going to look at fair use in a bit more detail. Fair use is basically a premise under copyright law that allows some of us to be able to use copyrighted work without the consent of the author, but you do so knowing that the law is the one that has allowed you to do that. And so, but there are particular mechanisms or conditions that must be fulfilled before that is able to happen. One of the other important aspects is also that it also defines expressions of folklore. This is something that I was really interested in hearing from the previous speaker, where we know that cultural heritage is not protected yet as an intellectual property right. We have general protection under some act, I think the recent act, which domesticated the Swascompum Protocol on cultural expressions and traditional knowledge, but we don't have protection that looks at cultural heritage in particular as an IP right where you can be able to earn if you are a community. The best way, I think many of us here enjoy cinema. You've watched Black Panther, you know about Wakanda. You've seen the costumes that they have. But many of these were borrowed from cultures across Africa. But when they go to Hollywood, they just call them Africa. But some of those come from Uganda. Some of those come from Kenya. And so it's important to be able to protect aspects of culture in a way that the communities, you that belong to these communities, can be able to benefit. So that's why we're really looking forward to that law. And again, I must add, one of the champions really has been Honorable Rachel Magola. This is an artist, for those of us that enjoyed Obangaina. That was a killer jam. She then decided to get into politics and became a member of parliament to really try and do more in terms of advocating for artists' rights. And so she's been instrumental in pushing for the national cultural policy, and we've also been discussing together with Uganda Law Society on how we can be able to have laws that will be able to recognize cultural heritage as an intellectual property right. But the amendment bill already looks at or has tried to include verbal expression, musical expressions, tangible expressions, colorback tunes. All of these have now been added into the expressions, sorry, not colorback tunes, but tangible expressions, musical expressions, and verbal expressions. These have all been included into the definitions of folklore, and these can also be able to get copyright protection as we already have them in our Act. There are also amendments to assignments, licensing, and transfer of copyright, where now it is mandatory for you to be able to register these assignments and for you to also ensure that these contracts are in writing. Again, I'll look at that when I'm looking at opportunities for lawyers. Under Section 4, there's an amendment under Section 14, which provides for a limitation period for circumstances under which transcribed work can be used online and for learning institutions, and it's important to ensure protection of the rights of the original author and fair use. Like I mentioned, under intellectual property law, we have what we call fair use. For those of us that went to university, we were given coursework and were asked to photocopy materials. Now the question is, if you go and you are told to photocopy a section from a book, and you photocopy the entire book, are you still operating within the realm of fair use? Especially, we know that you don't have money. As students, you don't have money. So, should it be allowed that as a student you can be able to photocopy an entire book? I'm asking you to see what you think. What do you think, those here? Does anyone want to try other than the AI there? Can you or should a student be allowed to photocopy an entire book? All of you are saying no. It seems you're not students anymore. That's why you are. No one is trying to advocate for the. No? Okay. Well, we have what we call the three-step test. The three-step test is employed whenever we're looking at fair use to be able to determine what aspects of copyrighted work can be used fairly without, number one, in special cases. That means the law has to prescribe what is fair use and what is not. Number two, it must, whatever has been prescribed as fair use, let's say photocopying a book, like in this particular scenario, does it interfere with the ordinary exploitation of an author's work? If it does, if it takes away money from their pocket in that way, then it may not be categorized as fair use. And then number three, which is the third step, if it does not prejudice the legitimate interests of the author. Now here we're looking at things like parodies. If I am going to make a parody of a song or of a play or of a movie, am I doing it in a manner that is criticizing perhaps or that is diluting this work and as such will prejudice the author? If I am, then that may not be categorized as fair use. So that is the three-step test that we employ. Another Section 14, some of the amendments that they also added under 14A are that if you are going to copy a book, limit it to 5% of that book. 5%. Now, we still don't know what 5% amounts to, if it also includes the cover page, if it includes the definition sections. Does it focus on the quality or on the quantity? That is for those that are using those exceptions under the Copyright Act. So we're waiting for regulations, and we hope that these will be able to define or to give parameters as to what we call reprographic works or reprographic copying. But this 5% is a step in the right direction. For authors, this is a problem that they have had, where all of you will go and photocopy Bachibinga's book or photocopy which other Ugandan authors have you read or have you used in school? Mugambwa, huh? Who? Musa Sekana, all of these, you have photocopied their books. Now this is saying that you will restrict to 5%. So I think this is progressive, at least on the side of the artists. For the students, maybe not so. Then you also have clause 13A, which also looks at the reversion of copyright to the author after 20 years. What that means is that if an author assigns copyright, and this is also subject to a contract of assignment. Now again, we shall look at that when I'm looking at opportunities for lawyers. But this law has made it so that lawyers are relevant. That at any stage, an artist, a creative, an author must come to someone who understands copyright law. And I'm really encouraging you as a member of the Uganda Law Society Intellectual Property Cluster, expand your expertise into these emerging areas. There is opportunity in these areas, and we can see that the law has created these opportunities for you to be able to go to your clients and say, do you have an agreement when you are assigning or licensing a copyrighted work? If you don't, do you know that after 20 years that will revert to the author or owner? Now, that is something for you to be able to take back to your clients. And then under 13B, we've also introduced what we call technological protection measures. These prohibit the circumvention of effective technology protection measures. For those of us in the past, I don't know if any of you had ever gotten a phone imported, especially like from the UK, which was locked to a mobile network. Or two, I think at the time, I've forgotten, Orange, etc., would bring them here, and then our guys would jailbreak them. And, or even those that play PASA, this is PS, they would also jailbreak these games, and you're able to have your, now that is illegal now, bagenda bakwata. So you need to be careful when you're doing that. This one is going to really take away a lot of work. Down, which side is that? I don't want to report. Then, so under section 13B, a person who does not apply to software products, services, or devices used to access copyrighted work for the purpose of research and innovation or for a beneficiary person should be able to do so in a manner that does not infringe on copyright or does not try to circumvent any measures that are meant to protect that particular copyright. So, outside of section 14, of course, they have also made it clearer that those that have visual impairments or that may have restrictions in that sense can also be able to use copyrighted work, again within the parameters granted, and it is possible to translate work into these sections, but it also introduces what they call a licensing scheme. So that's also an opportunity for lawyers, that if you're advising someone to have a book, then you know that fair use is going to be something that other people may benefit from that particular work. Create a licensing framework. That can be an open license or even a particular license that would guide or give guidelines as to how that copying should be done. Clause 8 also provides for the insertion of section 14B, which is a provision for application to the minister for license for anyone who intends to exploit what we call orphan works. Orphan works are works that do not have a mother and father. They don't have an owner. So this the law has looked at in the sense that if there is a piece of work that you want to be able to use, it is still, you can see it is still in circulation. It's not something maybe where copyright has expired. You can apply to the minister to allow you to use that work. And I feel this is a step in the right direction because intellectual property law generally is a facilitator for trade. So no one wants someone to be able to register copyright, register trademark, get a patent if they are not going to use it or get some benefit from it. Of course, we know that IP, especially copyright, also enforces what we call a moral right, which is the right to be identified as an author of a particular work. But really, as lawyers, what we're mostly interested in is that economic right, which is the right for someone to make money, because ultimately, if they come to you, you will bill for your services, and that's how you'll be able to grow in your profession. Section 30 was also amended to ensure that where sound recordings are published for commercial advertising purposes or used generally for any purpose, money should be able to go to the producer and, of course, also to the performer of that sound recording. Now, this is interesting because we have in our legal jurisprudence something we call image rights. Have you guys heard of that? Yes. Image rights relate to what we call the right to publicity. And so what that entails is that if I have a feature on me that perhaps will be able to sell a product, if I have a unique voice, I have a unique face, I have a unique hand, whatever it is, I can be able to, my likeness can be used in an advert, and that will then be able to make money for whoever wants to use me in an advert. But we don't have this right in our laws. We have it in our jurisprudence. We have it, I think the locus classicus we have is the Winnie Asege case, Winnie Asege versus Opportunity Bank, which was one of the first cases, that enforced this right in our jurisprudence in Uganda. And we've had subsequent cases, Basajabaka versus MTN, and many others now, that have enforced this right to publicity. Now, in many respects, we look at it from the aspect of brand, this is someone's brand or likeness. But if you look at this amendment under Section 30, if they are saying that if you are a performer, even generally copyright, if copyright recognizes performers and recognizes that they have a particular right in that performance, that in essence is a right over their likeness, over their voice, or over their interpretation, if they're dancing, if they're acting, etc. Now, all of those, if they're entitled to be remunerated, what about a model? What about you who is used on a billboard or on a poster somewhere? Now, we are saying that at the moment we don't know where that right should fall. The easy answer is that let's have a sui generis act or law that looks at image rights. But it could fall under trademark law because we're looking at a brand, although that may be a bit tricky because, of course, for brand you need to have that aspect of graphic representation. So maybe, since we're also the radical new bar, we can also advocate and say, can we be able to have this right recognized the way you can have a performance right? And maybe that can either fall under the Copyright Act or, like I've said, a separate act on its own. I had a discussion with this with a CEO of Euro, Uganda Reproduction Rights Organization. It's a collecting society which focuses on helping authors be able to reap from their work. And he was saying that, no, it can't necessarily fall under the Copyright Act. And I do agree with him, but in thinking about this a little bit more critically, and then also understanding that I mentioned a performer is that right is actually an image right, because it is their image or likeness that is used, is their voice, which also forms part of that. So if that can be covered under copyright law, maybe it is possible that that right can also extend. And I think Justice Adonio also mentioned this, talking about how copyright law can extend to image rights. I felt that deserved a few minutes for us to be able to talk about that. Section 34, this one for the lawyers, you'll be very happy. Contracts relating to publishing, performance, and broadcasting shall be in writing, signed and marked by the parties to the contract. Again, that is work for you. So if you see any artist, any publisher, any author, any performer who is going to go on a concert or anywhere, ask them, do you have a contract? If you're saying that bangambi baja kunsasula 50,000, baja kunsasula how much money, whatever these artists earn, and you ask them, but you say the law mandates it that you should have a contract in writing. So please, for the artists, for the performers, for the publishers, and for the broadcasters, your contracts have to be in writing. It has to be formalized. Section 39A is also a new insertion into our Copyright Act. This is the one that looks at contracts relating to quarterback tunes. And at the moment, before, and this is something the previous speaker mentioned, artists would get maybe a fraction, 10%, sometimes even 5% of a particular quarterback tune. I saw a clip from Palazzo before this amendment was done, how he was explaining how much the telcos earn from a callback tune. It was very difficult to listen to, Telco apparently would earn about 80%. So if Palazzo has sung a song, okay, I don't know, maybe, I hope he's not listening, but let me focus on Shiba. Nkwatako. Huh? I know that one. I know that jam, yeah. So I sang that jam, and someone then, it was a banger indeed. And then you have it, Robert here has it as his collar-back tune, all right? He has it as his collar-back tune. Now, you are enjoying this man's music, but then the telco, or what the aggregators, the telco is earning 50% or 60% of that. The aggregator, this is your agent who has told you I can be able to monetize your song, is going to earn another 30%. Then you are left with like 10%. And of course, you as well, you also have your lawyer who also wants to get 1% or 0.5%. Are you seeing how your cake is being lessened? Now, by law, they are saying that an author or performer has 60%. Well done, you who represent artists. 60%. Aggregator, any other person involved will own 8.5%. And then the operator, 31.5%. This is progressive. And again, I must emphasize, this is why policy is important. This is why, as ULS, we must be interested in these laws as they come out. Do we have laws that support our clients and support these industries? Do we have laws that are able to help us to grow and to thrive in whatever field that we are in? This particular clause, we feel as a cluster, is very progressive in that regard. Then you also have provisions for collecting societies under Section 56, which is, they have now introduced a process for formalizing the registration and also making sure that they are more accountable to their members. This has been an issue, especially on the music side. UPRS has been in the press many times over the fact that artists are saying we don't see this collecting society does not necessarily work for us. Work for us. There's also discussion as to whether we should liberalize. If that happens and UPRS still continues to not support members, should we continue to only have one collecting society for one band of rights, as the law is? So the moment you can only have UPRS for musicians, you can only have Euro for authors, you can only have, I forget the collecting society for dramatic works. But maybe if we had 2 or 3, they may be able to compete in that regard. Perhaps the market is still too small for that. Perhaps we still need to give a chance to these collecting societies to be able to thrive. But that is an opportunity to be able to make things better in that regard. And then there's also a provision for payment of royalties to members, owners of copyright, who are the appropriate beneficiaries. And also making provisions for any other person entitled to a benefit. So this serves to not leave any validly entitled person out of getting paid for their contributions towards copyright or for any work that it has. And then, of course, for those of us that are really interested in the law and why we go on these treaties, we send our ministers, we send our representatives to go to these international bodies to assent to treaties, and we hear that many of them then are shopping or doing other things, because when the law comes back, the Berne Convention was in the 1800s. The Marrakesh Treaty, okay, that one is a little bit more recent, but I want to give you the years so that we are on the same page. If I look at the TRIPS agreement we ascended to it as Uganda in 1994. The Beijing Treaty in 2012. That was on audiovisual performances. The Marrakesh Treaty, which allows access for those who are blind or visually impaired or print disabled, 2013. The Berne Convention, 1886, 1800s. World Intellectual Property Organization Treaty, 1996. And then the WIPO Performances and Phonograms Treaty of 1996. Why are we just domesticating them now? They say it is never too late, but again, this is why, as a body of lawyers, we should be interested in the law that we are saying we are trying to protect or practice. These acts, if domesticated, help us in terms of being able to open up revenue streams for us, but also help our clients to ensure that their works are protected and ensure that we have a vibrant community or society. So I wanted to also give you notable provisions of the Marrakesh Treaty in particular. This is for the visually impaired. Under Article 4, there's a provision for limitations and exceptions to copyright rules in order to permit reproduction, distribution, and making available to the public. I already mentioned to you the 3-step test, which looks at aspects of fair use. Under Article 13 of the treaty, it also establishes an assembly of contracting parties whose main task it is to address matters concerning the maintenance and development of the treaty. And of course, this has now been domesticated in Uganda, and Article 7 relates to the obligations concerning technological measures. Contracting parties shall take appropriate measures to ensure that when they provide adequate legal protection against circumvention of effective technology measures, this legal protection does not prevent the beneficiaries from enjoying the limitations and exceptions provided for in the treaty. We also have a few areas of concern. Of course, for the artists and for the creatives and publishers, this requirement for licenses and assignments to be in writing can be a challenge, but that can be resolved by you being able to talk to your clients to emphasize the importance of this writing. Over criminalization as well, we have fines of up to 2,500 currency points. How many artists will be able to pay 50 million shillings as a fine? Will we be able to enforce this act as it is? We informed Parliament that these were issues that may be difficult because we have to have a law that is easy to enforce. So we're yet to see, but they're saying, of course, that if someone sees 50 million and they'll be scared to be able to infringe. As to whether that will work, only time will tell. Also, the technology protection measures as well, the fine is 2,000 currency points and 7 years imprisonment. So these are some of the recommendations we took to Parliament as Uganda Law Society. Also, the due process in takedown. The law also introduces what we call a notice and takedown requirement. That if there is infringing content somewhere on a website, somewhere on a social media platform, you can notify the person to take down that song, that book, that play, that poem, whatever, has gotten copyright protection. But we're saying that if they're going to take down that content, if you're going to convict someone for that, let some money also go back to the author or owner of that particular copyright. And also, the definition of a service provider is too broad, which includes any public entity that provides for use of its services to communicate through a computer system. So perhaps that may need to be restricted in that regard. I will end with opportunities for lawyers, which really I've already mentioned. Guys, when you read about the numbers of enrollment and how many lawyers we are, I think now we are in the thousands. How many of us actually have opportunities to practice law? And really, this is a challenge, but it can be solved, again, through what we're looking at here, policy. How can we have laws that create more opportunities for lawyers? How can we encourage our lawmakers, government, to ensure that this local content thing is enforced? That if you're getting instructions and you know that you will have a Ugandan on those particular instructions. And for those lawyers that are also interested in learning, like I mentioned, you can only learn if you're interested in growing and if you also look for these opportunities and for this knowledge. And this is why as ULS we are such a powerful institution. We have a mandate and we have the opportunity to be able to change and influence laws, to expand them in such a way that it creates opportunities for us and for other lawyers that are coming into this particular contest. I know, for example, that for the last 8 years as Uganda Law Society, we have hosted an annual law symposium on technology and intellectual property. This we have done to be able to bring back to the members, so that as members of Uganda Law Society, you continue to discuss with the industry in ways that is collaborative. The previous speaker mentioned many opportunities where we are saying that we have a law, the Security in Movable Properties Act, simple, that allows you to be able to use your intellectual property certificate as collateral for a loan in the bank. But how many are doing that? Because the banking sector does not receive or accept these forms of IP as security. They're still asking for land titles. They're still asking for cars. How many of our clients have these things? Why can't an artist, or if you're creative, use your poem, your song to be able to go to a bank and get a loan? But that can only happen if Uganda Law Society is working with entities like the Uganda National Cultural Forum, is working with other bodies and other associations like Uganda Musicians Association, where we can all be able to see how can we open up revenue streams and how can we also be able to ensure that things like IP can be taken as collateral. It's sad here we have only one cultural center for all the districts that we have. We have been fighting and arguing, saying Ugandans, we don't produce, but there are opportunities to produce. We just need to be able to hold and get those opportunities together. So like I said, the provisions that provide for contracts to be in writing, those are all opportunities for lawyers. Know what this act is about. Know what intellectual property is about. IP is no longer an emerging area. It is at the core of business, at the core of industry. And now they are saying that for any creative, for any publisher, you must have a contract in writing if you're going to assign or license any intellectual property right. We have clauses on revision of copyright to the owner, like I mentioned, after 20 years. Again, this is a chance for you to advise clients, to be able to tell them, be careful if you are signing or licensing, make sure that it is clear that you're receiving these rights for life or in perpetuity. So that if someone later on passes on or you pass on, that can also be able to go to your family if you're the one who has acquired an intellectual property right. Also, these aspects on prohibition of circumvention of technological protection measures. If you specialize in these niche areas, technology, media, telecoms, etc., these are areas that can be able to introduce to you more opportunities. Of course, these sections that give remuneration to producers and performers, the callback tunes and things like that, especially that there's a section, that section of contracts in writing. It actually specifies what should also be in that contract: a date, an amount, the duties of the parties, the rights that you are or that are going to be exploited, and any other clauses. If those are not in a contract, that contract is voidable. It can be held not to be in effect. So these are all opportunities for lawyers to be able to handle that. And maybe I'll also say this is also again a mandate as ULS. When we talk about rule of law, we'll focus only on one aspect of rule of law, which is governance. But rule of law actually means that the law should be applied consistently, fairly, and transparently. Now, this also means that acts like these should be applied in this manner, fairly, consistently, and transparently, even for the stakeholders like advocates that depend on these laws for their bread and butter. I already spoke about image rights and other opportunities. Maybe that is what I will end with. When we went to Parliament to share the amendments, we also were there with members of Uganda Musicians Association and other associations, and we can see really that as ULS, we should continue to collaborate and work with these organizations. That aspect of collaboration not only grows them, but also grows us as well. I hope this morning and into the afternoon, I have tried to explain to you about copyright. I've tried to also share with you the amendments we have in our Copyright Act. And for the young lawyers and for the lawyers that are interested in growing, I hope you'll also be interested to come and we eat together when it comes to intellectual property and these other areas of specialization. Thank you very much for your time.
Wow. Advocate Kenneth Mohanji, at the exit, we are going to charge these members for this lecture. This was very, very comprehensive and deep. Let's give a round of applause to Advocate Kenneth. You have done an off-the-cuff presentation, and yet we didn't give you so much time to prepare. While I had the privilege to attend to the session in Parliament with him, he is the godfather for IP and the ICT cluster for the Uganda Law Society. I can't say I didn't speak much, but Advocate Kenneth did all the work with his team. He's a representation of a cluster of over 80 to 100 advocates. As the Uganda Law Society, we have a categorization of clusters. Those are specialties: family law, IP law, land law, and each of them is tasked to assist the society. As you know, we are over thousands, like he has said. So Advocate Kenneth is one of those leaders. He was the team leader at that time, alongside Advocate Brian Kajubi and Advocate Dina, yeah, thank you so much for this that you've done. You've broken it down this time round to the members. The opportunities are immense. I don't know if I can copyright my voice. after this. I don't know if you're going to charge me for the consultation. I will come. Thank you so much. Those days, Uganda did not have so many artists on the map like it was those days, the years that he has mentioned. Professor J from Tanzania, Nonini, Nazizi, all those. And then that's when the Chameleons came in. Now he is a Shibaholic. Shiba was also called. She's one of the top artists in the country. She was approached yesterday, but because she has different programs, she wasn't able to. She sent her apologies for you to know. Lillian Mbavazi was approached. Eddie Kenzo was approached. Fat Boy. We approached so many of them, but also they have an organization. And you know, we're all busy people, so we want to take the opportunity to thank the presenters. There was a matter that came up for one of the top artists in the world called Conscience. You remember the image rights issue? There's a question that has come about it. I believe you're going to, I think, break it down to solubility. Ladies and gentlemen, today was very eye-opening. It was very important, especially for the young lawyers. I don't think you have any reason ever to be broke. The Godfather has called us to eat. He is a lecturer. At the end of the day, this has been a free service. Pro bono. The Uganda Law Society, the Radical New Bar, like you've heard, he's also radical. We want to associate with you from KTA Advocates. The Uganda Law Society does this for a living. Our role, our mandate is to bring forth access to justice, and we use stewards that have been sent from God and stalwarts for the Uganda Law Society. So thank you so much for the council that has graced us with this opportunity to hear from top advocates who are young. Of course, you look at Mr. Jede, who is talking of Paul Kafero, nothing taken away. This time around, he's talking Shibaholic. He's, you know, a little bit of our own. So feel free, when we finish this session, to approach KTA Advocates, to approach Advocate Ken, so as to broaden your scope. The young lawyers are struggling. They keep saying there is no work. They cannot get any work after they have graduated. But you have friends who are artists. Be you in Gulu, be you in Arua, be you in Kavale, there is at least an artist that you have either interacted with, and because of the fact that you're a lawyer, they have offered you. Advocate Ken, in any case, Section 34 for me has spoken to me. That contract, you can ask me anything else, but Section 34 I will do for a paper. That is a contract that they have even given you the answers, how it's supposed to be spelled out. That without which it is voidable. You all know the meaning, but voidable is supposed to mean it can't be enforced. So you've already been given a format. Ladies and gentlemen, especially the members of the Uganda Law Society, but also to the general public, the press, and colleagues out there, this information is out for everybody. We are all beneficiaries. You have a relative who's an artist. You have a relative who can write a poem. You have your very own self. So we want to thank you once again, Advocate Kenneth. We are so indebted, so indebted. Thank you so much for this opportunity. And Mr. Peter, HRMU hasn't seen any of you yet. Human Rights Management Network, Uganda. Thank you so much once again. We are grateful. Ladies and gentlemen, it's the time for question and answer. We don't have so much time to spend out here. We know you're all busy people. We want to take questions from within. I don't know if there are some questions within. There is a microphone around. Yes, Adam, you have a question. Kindly move forth. Thank you so much. Those that have questions, those that are online, kindly type in the chat box. We're ready to take the questions. There is an able team to answer your questions. And those that are physical, please raise your hand up. Thank you.
Okay, thank you so much. The MC, Councillor Jirua, litigation, and our visitors and the media. My name is Adam Nwamanya, and I head communications here. My question goes to Uganda National Culture, that one. 75% of the child's life is spent in school. I'm talking about the future of creatives. It's spent in school. All of us here who are parents, our children spend 75% of their life in school. Currently, we have a standoff between science, perceived science in school, and the arts, where the arts sector has been looked down upon. They are not workers in school in terms of remuneration. Someone who is a perceived scientist earns 4 million, this one earns 400, and we have a primary school where children are taught science. They are also taught art, social studies. One day I was chatting with my Radical New Birth president, Isaac Semakade, hosting a next space. And there is this sort of music interlude, which I usually put before the space starts. Jirwa, you can testify. And when I stopped it, he sent me in my inbox, he was like, Adam, respect art. Respect art. But I wanted to know from UNCC, aren't you aware of these things? When you hear the head of state scorning, ridiculing, telling people to study arts and humanities, when he's telling them that for you, wait, your time has not yet reached, don't you feel hurt? Don't you get concerned? Don't you ask yourself about the future of the entities that you are heading? I want to know whether people are watching, man, I will cut this video. I want to know whether you have ever taken steps to engage the powers that be, and you ask them, you say, hey, look here. Yes, science contributes to the development of this country, but look at arts. Right now in Uganda, when you talk about anything regarding entertainment, during our Tech Fest, we had Azawi here, not so? That was creative, that was art. So a teacher of music to teach, to groom another Azawi, who is currently despised in school because he's teaching arts. What is UNCC doing? I just need to be enlightened about that. Thank you.
Thank you so much, Adam. We shall just take them down, then we can allow you to roll with all the questions. There is another question out there. Miss Agnes, kindly.
A good afternoon to you all. Yes, my name is Nambiru Agnes, and it's such an honor to be before my former lecturer, the gentleman that made me love IP. So I'll start with an appreciation. I would like to appreciate the whole, I would say, body, or the group of people that have pushed so far for copyright to come this far and for the amendment of the act. But of course, there's some loopholes. I had the first gentleman talking about strengthening some of these bodies. And in my heart, I was like, how best should we strengthen them? Because is it financially? Is it educative-wise? The truth is that when you talk about copyright out there, the first thing that comes to people's mind is musicians. People don't have a clue of the things that Advocate Muhanji has been talking about, moral rights, economic rights, all that. They literally don't know. And in as much as it may look as if we are taking away the job from the lawyers, I believe in empowering the bodies that the first gentleman was talking about. I believe people should not only look at it in the financial aspect, people should look at it in educating these bodies about what copyright really is. People have no clue. When you mention even the musicians, it's unfortunate. I was watching After 5 one day, and I had, God forgive me, let me not mention the musician. And he was talking about copyright, and he had no clue of what he was explaining. But you would see he was just using emotions and talking about money. Emotions, money. I believe that the best way we should empower those bodies that the gentleman was talking about is through creating more ways to sensitize people about what we are talking about. Then secondly, my question goes to the aspect of aggregators. People look at copyright, like I said, in regards to musicians alone. But there are children that are making statements on TikTok that are going viral. And these are not people that are, let me say, musicians. In as much as the musicians, the Musicians Association is the budding issue right now. But I believe if the government is talking about raising finances and growing people out of poverty, they should not only look at growing the copyright aspect of it all as a relief to musicians only. They should look at it as something that should benefit them as a government in reducing poverty one way or another. So my point is, what has been done, or how far has pushing copyright in regards to the aggregators, let's say TikTok, let's say Snapchat, you're looking for a sound and you realize there is a kid in the village that made a certain sound but hasn't benefited from it. Because most of these aggregators like TikTok come to these countries knowing very well that our copyright law is not as strong as we think it may be, and they take advantage of these children. Yes, so I think I've driven the point home. Thank you so much.
Thank you so much, Agnes, for that question. Any other that is in-house? Yes. Okay, please. Are you ready?
Thank you so much. Happy to see my former lecturer.
Council.
Yes. So my question goes to Mr. Kenneth. He talked about 3 steps when it comes to copyright. However, I wanted to know, how does these amendments or this amendment strike a balance between the creators' rights and the people's access to knowledge? Because when you look at the example he gave us, where he talked about photocopying a book, you realize that this person is only photocopying this book to access knowledge. However, when you consider these 3 steps, you realize that again, he's taking away the creator's rights to economic rights. So I wanted to understand, how does that strike a balance between those 2 people? Thank you.
All right, thank you so much. We would like to request you to first take those. We have some questions coming from online, but I think that is already good for us to start. Mr. Jede, if you don't mind, you can activate that microphone to allow you to be in your comfort. Thank you.
Thank you very much. I hope I'll be able to respond to this. The standoff between science and art. Maybe before I can even answer that, I would like to give you something that I went through. I was invited to Paris by the French embassy as a guest, the way you have done here, and to stay there for about a week. And the whole thing that I was invited for was to be able to appreciate the nexus between art and science. I was taken into the spacecraft. I hope you understand the way where they used to propel the space, the aircraft, the craft, the things that are going to the spacecraft. And I was taken there to see how it used to be done. It's an old area that, and then they have changed the whole area into an art area. So they're actually saying that the things that were made to fly to the space were designed by artists. So they were trying to make me understand that the designs that were done was done by an artist. But of course there needed to be science to propel it to go to the skies and do whatever it is. And even when it was there, the other designs of how it will take pictures and motions and so on was also a combination of both science and art. Now, that impression that they were giving me was to clearly understand that there is a very, very strong nexus between science and art. Obviously, as a country, we experience different levels of development. In the first world, I'm talking about Paris and all those countries, they're already in the first world. They've already gone through these stages we're in. For them, they're more into, trying to see a nexus between science and art. For us, we're still looking at how do we develop our science. We still have an issue of our science and technology. And I think in terms of government, they're not saying that art is bad. They're just saying that how can you bring up science? I remember when I was in Makerere at my time, there was a big cry that women have been left behind. And government came up with a policy to say, give women 1.5% as an additional 1.5 points as an additional thing to step up the numbers. I am sure today you'd want to review that because the numbers of women is actually becoming more than the number of men in terms of the intakes in the university. Policies are made in times, depending on the situations. And I'm sure this particular policy was made for this time, to bring up artists so that we could have many more scientists. I'm sure soon it will also be adjusted so that there is a complete nexus between science and art. So that's my perspective on this question. So debates have been on, and lots of debates from my colleagues in the art is that, why do you want to demean us? Why do you want to make us look like we're not very important? But I think the answer is no. Let us focus you, do your area, but for now, let us bring up scientists, so that when we have a more vibrant science sector, because we completely do not have the science sector. Thank you very much. Then the second thing that you also raised, and I think you give the answer, is the issue when I talk about strengthening institutions. Obviously, you are right. We do not just want to strengthen the institutions in terms of resources, in terms of money. Money is not the only thing. We started by the institutional framework. We're looking at the laws. You remember I'm talking about 1959. That law in itself, if you look at it, you may not even run an institution because the law inhibits you. So institutions need to look at progressive laws, review them, and make them, speak to the community. Secondly, you need to also, like you said, we need to make people aware. How many people know that there is an institution called Uganda National Cultural Center? How many have looked at that law? How many understands how it contributes to your well-being and so forth? So there is the aspect of awareness, and obviously you need to do the sensitization and make sure that the people are sensitized to understand that these are areas. That is not to forget that in terms of insight, there needs to be a broad capacity building. And I'm not talking about skills, knowledge, and attitudes. I'm talking about broad capacity building, including equipment, facilities, and including that. So I agree with you. I think those are the areas that we need to focus on. Thank you very much.
Thank you so much for that. Advocate Ken, you had some questions. Are you able to take them down?
Yeah, sure.
Very well.
Maybe I will just start by adding something here.
All right.
For those of you that are interested in K-pop or those South Korean movies or shows, I'm sure you're there, but you're just hiding. Anyway, I was looking up stats. In 2021, yes, they generated South Korea $12.4 billion in export revenue.
Wow.
And over the years, that has increased, especially compared to the share of its GDP. Same thing with the music industry in the UK, in South Africa. Nigeria now is, their creative economy has contributed a huge chunk of their amount. So for me, I feel this discussion of sciences, arts, yes, we need to industrialize, we need to be able to produce, but the creative economy also has a lot of potential in that regard. And I think our colleagues there are right, that I think if you try to compare them to the sciences, that is not perhaps the right way to be able to look at it. But I'll answer the question around the three-step test. So fair use, like I mentioned, is meant to encourage those who may not have the funds or may not have the means to be able to access copyrighted work to be able to access it, but with those specific restrictions. Now, this aspect of reprographic copying, honestly, my view, and this is my own view, is that it is a problem because the way that the amendment is worded, it says a person who carries out reprographic copying of passages from published literary or music works shall not reprographic copy more than 5% of that work at any one time or within a period of 3 months. Now, if you go back to section 14, section 14 already provides that you can be able to use copyrighted work fairly if it is for private personal use only, if it is a quotation, if it is for teaching purposes, at least to the extent that it does not prejudice the work. Again, for me, I don't know how that 5% came up. And in balancing that interest, I don't think 5% is a balance. Would have to understand what that 5% means, especially they say within 3 months. So that means within 3 months, I'm restricted to 5% of copying. Now, if I am a student and I have coursework and I'm meant to get this book, if every week I'm meant to photocopy some of that work, how can I do it in a way that will not infringe on copyright or that is still within fair use? So I feel that we still need a bit more guidance on what this 5% amounts to. Ultimately, the balance should be that the author is not prejudiced or the author does not lose out if someone is trying to use their work. But on the other hand, that there are people who need to access this work without these restrictions. And so I would hope that we spoke about this in Parliament, and I do hope that the legislators there will be able to take our recommendations to heart, and in particular be able to do more in striking that balance when it comes to the 3-step test. Because I feel the way it was, for me, it was working. Well, the authors will say that there was that particular problem of photocopying, like I mentioned, an entire book, but I think that is now in the extreme. But if there was another way to be able to address that or to align that, I feel that that would be better. So the balance is, you strike the balance based on the author's interests to be able to earn from their economic rights, but also these marginalized groups or groups that cannot get access to this work, how can they be able to access that work in a manner that will allow them to exploit it, but without taking away from the owner or holder of that work.
Thank you so much for those answers and the questions. Those physically, Mr. Jede, you seem to have everything as a tat-a-tat. We have some questions here from Nixon Okello. He asks, it's quite a long read. I'm going to try to read it slowly so you can take note. He says, Mr. Jede, many Ugandans still hold a conservative view of the creative sector. Parents only believe in careers like law, medicine, or engineering, have been considered more prestigious, while the arts are often looked down upon. Almost what Adam had asked. What role does UNCC play in changing this perception? What initiatives has UNCC undertaken to help society appreciate the value of the arts? And what more needs to be done to shift mindsets and support the growth of the creative industry? That is from Nixon Okello. Thank you so much, Nixon. We appreciate. And we have another from Nsubuga Rob. He still asks unto Mr. Jede, during the recent national budget reading in July, the Minister for Finance announced an allocation of Uganda shillings 66 billion towards the creative arts, the highest ever for the sector. Part of this funding will go into establishing a state-of-the-art high-tech city. Could you tell us more about what is high-tech city, what this high-tech city entails, and how it is expected to transform and promote the creative industry? And finally, we have one from Tracy. Thank you, Rob. Tracy asks or states, let's say, Mr. Ojede, you talked about enforcing taxes on bar owners and other establishments. These are very attentive members. Where the proceeds will be, the question is maybe, where will the proceeds be distributed? No. Where the proceeds will be distributed to artists. Okay, yes, let's read again. Mr. Jede, you talked about enforcing taxes on bar owners and other establishments, where the proceeds will be distributed to artists. How practical is this? Do we have examples where artists have earned in such a way? We shall take those three that have come from the online attendees. Advocate Muhanji, you will have some. I think we'll just allow Mr. Ojede to take his, and then we shall roll to the advocate. Thank you so much.
Thank you very much. To Nixon, I think you're very right. There has been very conservative view about art and culture. Even my parents, when I was growing up, they would not really want you to sit with the aspect of art. And this is because, one, at the early stage, art was misconceived. It's a bit about misconception of art. And then secondly, and I told you earlier on that if you talked about culture in my area, I mean, people are looking at other things. They're not looking at the creativity that you have. But of course, if you look at it today as CCI, the creative industry, and even the wording itself changes it to become an issue that brings out the aspect of creativity. Today, a lot of artists I know are now taking their children to international schools, not because they want to do the international aspect, just because they have opportunities in the international schools to teach their children to be an all-rounder. And therefore, you find a lot of them having strong aspects of art. They have realized that there's money in that area. In the olden days, there would be no money in the area of art, but as I've given you statistics from today, you realize that this sector has a lot of money. And therefore, we need only to now be able to sensitize our public, the parents, to know that this area that you're stopping your children to go for is actually an area where your children are going to become millionaires and billionaires. So sensitization and information sharing is very important, both to the public, general public, and also to our policymakers and all that. So I think the conservative aspect will definitely is changing, because if you see in the other world, artists are actually the most preferred people that you will talk about. The 66 billion that government talked about, again, this is an area that has been broken down into so much. I'm sure you recently saw that some of the cultural leaders, the traditional leaders, if you want, were given vehicles and support and so on. That this particular money is inclusive of that, the 66 billion. It's not just that they've given it to all the artists. They've given it to cultural institutions, and they take the bulk of it, almost, I would say almost 30-something billion out of that. And they are clearly very clear indicators, because as we talk now, every cultural institution is supposed to be paid 60 million per month, cultural institutions. And we're talking about, 15, 16 cultural institutions, and every month getting that. They need to be facilitated the vehicles, and each of them getting 2 vehicles. They have to have their homes and palaces. So that takes a big chunk. But of course, I would love to talk about the money that then remains, which is about 28 billion. This particular 28 billion is allocated in the form of 5 billion has been given directly to the federation, the Film Federation, which is to enable them to work out modalities on how the film sector can grow and the film sector can be enhanced so that they can market it and make sure. So 5 billion is directly to the film sector using their federation. And the remainder, Obviously, there is some part which has already been allocated for purposes of government has decided that instead of continuously giving artists money, we should be able to establish what we call SACCOs. And we're going to establish SACCOs across the country for artists. Remember, I was talking about access to financing. So we're saying that to deal with the issue of access to financing, a bigger portion, almost the 18, but there's 1 billion which is specific for an institution that is established called WALK. West Nile, Acholi, Lango, and Karamoja. They formed up all these are musicians mainly, and they indicated that they do not want to be part of the Federation of Music in Kampala. They want because it's far away, and then they were allowed, and that they will take about 1 billion for their case, so that they're able to also be able to do that. So we remain with about 17, which is now going to enable us to support SACCOs across the country in terms of regions. The original region we're talking about in terms of government are 17 or 18, 18, but we thought that if we spread that money into 18 regions, then it will not make sense. It will not, because then the amount of money becomes less for borrowing. So we have decided that we have 5 regions, and in which this money will be put into SACCOs, where artists are able to access and be able to do their work. So that's the kind of money that was given out in terms of that money. To Tracy, the enforcement of taxes and all that to bar owners and so on, I think like my colleague said earlier on, that is the next stage that we're going to. There needs to be regulations and guidelines on how this should be done. And I think this is where you also will be involved. You need to participate in it and say, if I am to have an artist perform in a bar, or I have the bar to play my songs and music and so on, how much should it be? So that becomes a regulatory issue, which I think is also being worked on, and you will definitely be involved, because we still don't have a proper answer. But all we know is that they must be able to pay for it so that nobody is cheated. And I think that is the answer that I could give for now. Otherwise, thank you very much for those questions.
Thank you so much, Mr. Ojede. SACCOs for artists, lawyers, that's an opportunity. Wherever there is a SACCO, we all know that there is need for framework to be formed and explained. We are joined by the Vice President of the Uganda Law Society, Advocate Anthony Yasimwe, who has just come from the Court of Appeal overseeing an enrollment session of more advocates that Advocate Ken Muhanji has been creating a platform for. So for the new advocates and those that are young lawyers, today is a big opportunity for you to appreciate that even a SACCO for an artist or artists needs a lawyer. You don't need so much. All you need to do is look out for the artists in the areas you come from: West Nile, Greater North, Western, Chigezi sub-region, Eastern region. Just look around your place. You'll find that there is a SACCO or there is an arrangement created for an advocate to help. Advocate Kenneth Muhanji, while you were still in the niceties with the Vice President, kindly take note of the questions that have come from our online attendees. Please, there is one from one Gertrude Nambi, who asks, but thanks you first, and says, thank you so much for the presentation, Master. Sir, I don't know who you are, but I think this was one of your students. I think so in the university that we used to call our lecturers Master. She says thank you and asks, are proceeds from a copyright taxed? If yes, how does the URA track such earnings from creatives? I hope that is clear, Council. Then, wow, the next question is coming from one of your competitors for the person that you follow as your favorite artist. He or she is called KD, the Shibaholic. I don't know. I don't know. The individual, female or male, thank you so much for your question. You have a competitor here. In the person you're asking the question asks, does the amendment bill protect pharmaceutical innovations, or rather inventions? There are emerging creative trends of people creating herbal medicine, cosmetics in brackets, bleaching, chizigo, etc. Is their creativity protected under any law? Is there need for their patents to be protected? That is from KD, the Shibaholic. Thank you so much, KD. The last question for you, Advocate Ken, is from Ouma Vicent, who asks, but starts by thanking you. He says, thank you, Council. My question is on enforcement of the law. What does the bill say about government enforcing copyright law? I think there is need for a specialized agency to manage cyber crimes like digital piracy. Take it on, please.
Yeah, thank you. And it's good to have the Vice President here. Thank you very much. Proceeds from copyright taxed. Yes, from a tax perspective there, because if you're looking at it from tax, once you earn an income, that is a benefit to you, and you should be you're taxed or charged income tax. And then if you're also providing a service, that should also be taxed, where you should charge or ask for VAT, which is 18%. So the principle is yes. The reality, of course, is very different. Many will put in the pocket and go home. But generally, the proceeds are taxed. And maybe that's also another policy question as to whether all of these proceeds should be taxed, or how they should be taxed, if they should also be subject to the same taxation regime in regards to income tax and VAT. Yes, please. Then KD, that's actually not a competitor. We're in the same WhatsApp group. So you should, does the bill protect pharmaceutical inventions, herbal medicines? Now, you've asked a very good question, KB. I'm actually very interested in herbal medicines. They fall under a separate intellectual property regime that would be perhaps patents, where our law, our Industrial Properties Act, mandates that you can be able to get a patent or a utility model protection over a process for pharmaceutical products, and herbal medicines fall. And in my last reading, you can be able to apply for a utility model protection over the process for creation of these herbal medicines. We still have a restriction over getting patent protection for medicines in Uganda as a result of the exemptions from the TRIPS agreement that make it so that being a low developing country, we are not allowed by law, which is unfortunate, to protect medicines. And I saw actually an article in the papers, I think about 2 or 3 weeks ago, about this Professor Semfuka, is it? Who has created herbal medicines. But the headline was, Professor Semfuka gets patents in America. I was like, what? This is something that we are making, other than him getting that support from government.
Yes.
But the fact that there's a headline that he has registered patents in America. I don't know how you guys feel about that. But this is a problem in our Industrial Properties Act, which basically allows us to be able to create what we call generic medicines, yes. Which of course are important for those of us that cannot access essential medicines. And these can then be produced here locally without infringing on patent laws where those medicines come from. But on the other hand, they're restricting and making it so that we cannot register for intellectual property protection over these medicines. Yes. So we also do have a Traditional and Complementary Medicines Act. This is the one I spoke about that was also introducing aspects of cultural heritage. But they only recognize herbal medicines as herbal medicines or as therapeutics, but they do not necessarily recognize or create an intellectual property right that can be able to protect these herbal medicines. And I know that there is an association of herbalists called NACOTHA, which aggregates all other associations of herbal medicines. And these all have the same challenges, being that the law has not been kind to them in regards to protection of these medicines and how they can then be able to market or sell these medicines, such that if you're like Professor Semfuka or who is this professor who created Covidex, Professor Guang, you have to go to the US or other jurisdictions to be able to patent your medicines, which is such a shame. And then Owuma Vincent, the law has actually, the amendments provide stringent mechanisms of measures, they punish those who want to infringe on copyright. The fines up to 2,500 currency points, like I said, about 50 million, 30 million. So these have increased. Before they were in the thousands, but now they're in the millions. And yes, we still do have a problem when it comes to enforcement of laws. We have very good laws, but our challenge is the enforcement. So the bodies that are interested in this arm of punishing, other than the judiciary, which of course also needs to be streamlined or needs to be empowered to be able to hear these disputes properly, but even police and other bodies, they do not have the right resources to be able to actively enforce many of these provisions, at least in as far as cybercrime or enforcement of copyright on the side of infringement. So it is left up to the stakeholders to be able to do it on their own, or to work with them, and you have to release certain monies here or there, which is very unfortunate because it continues to perpetuate the problems that we have as a society, as a country, and as practitioners of law. Thank you.
Thank you once again so much. Let's give a round of applause for these very, very able individuals before us. I hope we have been edified with this very, very educative session for the day, both the members physically present and those that are online and the general public. We have learned so much, even from what we thought we knew, because, I mean, artists are everywhere. We always go to places of entertainment and events to attend to these artists. We pay money to attend to these artists or to enjoy their shows, and yet now we are realizing that as you pay that money, in a way or the other, as a member, as a lawyer, you can earn from that artist, especially if you have a relationship. And in any case, some of these artists, of course, don't know some of these things. While we were at the parliament and I was being led by Advocate Kenneth, we got a concern, and I think that was the basis of this engagement. The artists themselves were asking for a sensitization of sorts about the laws that govern them. I think that's the reason we're here. You've also heard from Uncle Peter, who has showed us clearly that we have a lot of work to do. So, ladies and gentlemen, the members especially, but we're not going to separate ourselves because we're all human beings and we benefit from this creative and cultural industry, the CCI. That is what we were told it is supposed to be called. We are calling on the members and the general public as a clarion call to see to it that you, one, benefit, but also see that your favorite artist or any other artist that you're aware of in the country or beyond benefits from his or her own sweat or the chain that is there. So we want to thank you so much. We don't want to spend so much time. We've had very, very deep discussions, and I'm very sure we've been edified. But before we get close to this session, we would like to welcome the Vice President of the Uganda Law Society, Advocate Anthony Asimwe, to give us a vote of thanks and a message from the Council, and also as the host of this session, as the Uganda Law Society, would like to hear from him and get some blessings as the radical new bar. Ladies and gentlemen, Advocate Anthony Asimwe.
Thank you very much, Robert. And thank you very much, everybody who is in the room today. I bring you greetings from the President, Isaac Semakade. He's been following online. And while I was, like Robert said, I was presiding over an enrollment of new advocates. Today, we received 125 new advocates who enrolled today, he told me, please find time and get to Secretariat and make sure you speak to the people who are listening in our Rnblive. I also bring greetings for the rest of the governing council who are not able to be here with us. And I thank everyone of you. In a special way, allow me thank our panelists, our presenters. I kept trying to chip in, and because it was really an interesting topic, but I'm very sure that the people who have tuned in today have gained a lot of knowledge, a lot of wealth. While speaking to the new advocates, I was telling them, this is exactly what I was talking about, that learning for any legal practitioner does not end. I told them that, signing into this book and crossing over from LDC and coming into practice does not mean an end to your learning journey. As a lawyer, as an advocate, you must keep learning the new trends. And I also I told them something interesting that exactly matches and, speaks to what we're doing here today. I was encouraging them to actually learn to do some kind of specialization and pick their niche. The trends in legal practice are changing completely, drastically. Whereas the numbers are growing, the feature of the legal profession in the country is changing at a very drastic stage. And having, individuals who take it upon themselves to do beyond, to do more than what you got from law school, to contribute in that area, it is not something we do not take for granted, and that is why I really thank the members here. I was actually using this as an example where I'm coming from. There is a time URSB was celebrating the World Intellectual Property Day, and the theme was about, I think, performing arts and culture, art, something like that. And I attended. While seated in the gallery, I was seated with some artists, and one lady, musician, told me, she asked me, said, by the way, okay, they've introduced us the Vice President Uganda Law Society. How come we don't see many lawyers in this area? Sometimes we need to sign contracts, sometimes we need to do things, but we lack guidance. And I asked her, you mean you've not met any other lawyer? She said, we only know. She mentioned 2 names. Those are the only lawyers they know in that field, out of the 6,000 members we have. And for me, it was a time for reflection and thinking, this is, a cash cow. I'm sure that has been explained. I don't want to go there. But you find the interest of the members who are complaining about, there's no money, no work, we don't see clients, have not picked interest to go into that field. It can bring in a lot of revenue, a lot of money. And that is why, as the bar, as the Uganda Law Society, as the Radical New Bar, have been so intentional in looking at areas that empower our members and the general public. I want to believe that Robert must have also explained the purpose of these engagements, trying to close the gap in execution of our mandate under Section 3 of the Uganda Law Society Act, specifically in assisting the government, members of the public, in matters touching the law, all those ancillary to the law. That's why you'll find the uniqueness of this platform is that not only advocates tune in to follow, we also have members of the public who are interested in seeing this. It's an obligation we are taking seriously because we want to remain relevant to the members of the public. It is our mandate, a statutory mandate, which we must execute. And from the time we started doing Rnblive, bridging that information gap, having people with knowledge come and share with the members of the public, the members of the bar, so that they appreciate, because we are talking matters of law, whose role is it? In the past, it had been abandoned, and much as we knew it is the duty of government to ensure that the public is, sensitized about some of these things. I can assure you, even certain laws are passed in Parliament, people never get to know about them. You'll even be in court and some lawyers are shocked when you cite a particular law. They are surprised, and this is a member of the bar. So we really feel we've had the support of people like this who come in to have an input, the members out there who are CEO. We also do not take this for granted. We thank you very much for always, for understanding the vision as to why, we decided to do this. As you're aware, it is a unique way of making sure we do our work away from the past. Again, as I conclude, you might be aware that last week we had the Digital Transformation Festival. And I think following on Monday this week, we entered into an MOU with Utamu University who allowed to partner with us in training of the lawyers. And part of the focus areas for training is this area, intellectual property, and how technology can be used, can be enhanced, how can use technology in that field. It is actually, I think, there are specific trainings, tailor-made trainings. And what we negotiated was for members to get subsidized, courses, the short courses, the long courses, and also free ones, so that we try. It is a way of being intentional about digital transformation. I'm very sure in the discussions about this, you cannot do away with digital transformation. You cannot do away with technology. It is at the helm of it. URSB was one of our partners during the celebration, and we kept saying, I think the Registrar General, as he kept telling us, how in all their systems, be it patents, copyrights, even registration, everything, for them they decided to go digital way back. So I want to believe that from the discussion and what I'm sure of, there must have been an intentional discussion on the embracing technology. They do this because a lawyer right now who cannot embrace technology is going to be very irrelevant in the coming, in the coming years. That is the future of practice. That is how we are going to get, this impact. And I know I missed part of it. I have loved to hear how Kenneth and Uncle Peter, what they would have to say about the use of AI in some of these things, because personally I love music, but sometimes these days, even when I open maybe YouTube, anything, I begin asking, is this a proper one? Is this AI generated? It's very hard to tell sometimes, every day. So those are some of the things we were discussing last week, and I'm happy that it is a continuous discussion, an intentional discussion. So let us keep using these opportunities. I'm very sure the gentlemen here are available and open to support and to guide, because trust me, that is where we are headed. We cannot run away from technology. We cannot run off from this AI that is coming in every system. As you're coming up with these laws, and something we're saying was how we now need to even focus more on legislation. We have these legislations coming up, but then with this advancement of technology, you realize a law has been passed some of those areas were not even included, but now it is something new that we must adopt. And as the Ugandan Society, you might be aware that it is also our mandate to assist or to advise on policy and legislation. So that is why we need the input of every member who has that kind of knowledge, the kind of experience and expertise, so that we are able to properly and, competitively advise and give proper advice. So once again, I thank you very much. Thank you for being here. Let's keep the conversation open, and let's also keep looking out for some of these opportunities. They are not just for a few members. I'm very sure any member out there, anyone can pick up, from now. It's not too late. And we become relevant to at least the members of the musicians are outside there waiting for people to support them in this area, and there's money. I'm not practicing a lot in that area, but now I'm taking interest in getting free lessons from his colleagues, so that I also join some of us are tired of being Chiwanja lawyers, because at the end of the day there will be no more Chiwanja. But on behalf of the Rnb Governing Council, I thank you very much, and have a good afternoon.
Words of wisdom from the Vice President, and in representation of the Governing Council, we cannot add anything useful to what has just been said. Just know lawyers can also be hustlers on the other hand. You don't only have to go to court, there is a lot of opportunity out there, and the artists, as many as the population holds 46 million people in the country. So you can imagine how much work there is. Ladies and gentlemen, this is what the Radical New Bar does: access to justice and helping the government in matters administration in as far as our statutory mandate in Section 3 of the Ugandan Society Act is concerned. Here we are, and we are very grateful. We have come to the close of this session. We are so grateful to those that are physically present, to those that are online, to the press, to the public, to our very distinguished guest speakers. We are so grateful. We got apologies from Mr. Martin Muhumuza, who is the head of research in the Uganda National Musicians Federation. He sent his apologies. He offers to make time the next time we present the opportunity. He has a lot to say. He was with us at the parliament making presentations, and we are also cognizant of the fact that people are busy in the country running here and about to try to make the country a better place to be for God and my country. We shall want to close this session by requesting the distinguished speakers together with the Vice President to come take a photo or a picture here for memories and records so as to set them out. Thereafter, they will be welcome for a plate or a bite to share, if it's okay. Thank you so much.